Here is your 50 state update for November 2025. Hey, I'm Morgan Davis. I'm a health and wellness attorney based in Raleigh, North Carolina. Let's talk about how to keep your business protected and thriving. One of the biggest needs in hemp and cannabis is an understanding of the constant ongoing change at the state level, at the federal level, and sometimes even the local level when it comes to regulations, administrative input, attorney general input as to what's going on in the hemp and cannabis industry. As an entrepreneur, you're focused on your business, as you should be. Or as a stakeholder, you're focused on the industry as a whole, as you should be. Hard to keep up with the various changes ongoing. So my gift to the industry once a month is we go through the last 30 days looking at what I think are the most significant changes, enforcement actions, or announcements from regulators and those involved in the hemp and cannabis industry. The theme for November 2025, hemp took a hit. So how are we going to get off the mat? It's December 1st, 2025. We're recording a little bit late due to the Thanksgiving holiday and all the things that are going on. So here's the most important things from the last 30 days. At the federal level, we all have been reading the news for the last 30 days. The Appropriations Bill put in some very bad language that goes into effect 365 days from the date of signing, which was November 12th. That will significantly change the Farm Bill definitions and the federal outlook for hemp overall. Now we've got 365 days to either get rid of it, renegotiate it, or prepare for what comes next. It will also cause lots of moves at the state level, and we're already seeing some of that happening. A little bit of good news at the federal level. Very quickly after the Appropriations Bill was signed, U.S. House Representative Nancy Mace from South Carolina filed a bill to basically repeal the section of the Appropriations Bill that would amend the Farm Bill and pull back all that hemp language that has caused this huge shift, or will cause a huge shift. The bill itself is very short. It essentially just repeals the language, and she is calling for a much more thoughtful and intentional debate at the federal level about a framework. She did vote yes on the Appropriations Bill, but voiced her opposition to that section in her vote. And so this is very consistent with that. They're not moving on anything right now, so it's not made any significant movement in the House. But we'll be watching that as the coming months, as we get into 2026. Bad news at the federal level. Federal regulations were published last week that give us the first federal interpretation of the new language under some new Medicare regulations. It interprets the language to say that anything that is not within the definition of hemp after the 365 days. So this is assuming 365 days passes. Nothing changes about the current law in the Appropriations Bill is passed. And we move into the new era and new federal definitions of hemp as they are outlined now. Then at that time, anything that does not meet that definition will go back to being a Schedule I controlled substance. Okay? The way that it's interpreted in these new regulations, even CBD, because it is not approved by the FDA to ingest by humans or animals, will be considered a Schedule I controlled substance. Now that's a departure from what most people thought about the Appropriations Bill. The idea, the rhetoric from Mitch McConnell and other supporters was that this would protect the wellness industry and would protect CBD. And as we can already see, that may not be the case. I'll leave a link to those federal regulations in the notes. Definitely check them out for yourself, but take this as an indication that we're not done seeing the different interpretations and potential outcomes of this language yet. We're just getting started. Chicago. So, soon after the federal bill passed, the governor of Illinois came out and said that he was calling once again for regulation of intoxicating hemp. While it has not happened at the state level, the Chicago City Council Committee on License and Consumer Protection is going to meet this coming week about a city ordinance that would completely ban the sale of hemp in the city of Chicago. Illinois is a massive hemp market. It's also a very strong cannabis market. The cannabis industry in Illinois has on several occasions tried to shut down hemp and make it go through, either shut it down completely or make it be sold through the regulated channels. Every time that has not been effective and has not passed. If this passes, it would be a big hit to the hemp industry in Illinois and comes with some pretty steep fines, which range from $2,000 to $5,000 for each violation and each day that the violation is not addressed. So this would be a really serious threat to businesses, especially in the city of Chicago. Ohio. So Ohio has a bill that's been moving through the Senate and the House that would move all hemp sales, all hemp products, to be sold through the regulated industry in Ohio, with a small carve out for hemp beverages through bars and restaurants and liquor retailers. That language made it through, but did not make it in the same form through both the House and the Senate. So now they're in a subcommittee negotiating on it. While that happened, the federal Appropriations Bill passed. So the language has further been amended to say that the carve-out would only last as long until the federal Appropriations Bill kicks in. So it would only be a year-long carve-out. After that, everything would have to go through the regulated cannabis industry. The Senate has not voted to approve the House version that was adopted. Their first opportunity to do so will be December 9th. The rhetoric is there's a great deal of confidence that it will pass and this will become law in the state of Ohio. New Jersey, Senate Bill 4509, similarly would revisits the idea of New Jersey putting hemp through the regulated cannabis industry, which if you remember back to a year ago this time, early fall of 2024, they passed new law which did just that, and then it was enjoined. Only partially, but it was enjoined and it stopped the entire thing from being put into place. This revisits that original idea, taking out some of the state-specific language. The bill itself was enjoined originally because it preferred state businesses and prevented businesses outside of the state from participating, which is a violation of interstate commerce. So that was enjoined. They've now are going to attempt to fix that. It's moving very slowly, though. It was introduced in May and has only just now been moved into the Senate Budget and Appropriations Committee in New Jersey. Wisconsin has proposed 3 different bills, 503, 606, and then one that has yet to be named, all of which take different approaches. 503 completely bans the sale of hemp products, adopts a total THC standard, and gets rid of most of what's available in the market. 606 keeps hemp alive, but it puts everything under the regulation of the Department of Revenue and essentially treats it like alcohol through a 3-tier system. There's another bill that's been circulated and drafted but has not actually been filed that proposes a more what we would consider common sense regulation framework. We don't see that it has a lot of support yet, so who knows if that will go anywhere. There will be a public hearing in the coming weeks. Mississippi. In June and July of 2025, this past summer, the Mississippi Attorney General issued an opinion letter stating that their belief was under the existing law, hemp products, especially consumable hemp products, are illegal under Mississippi state law, and that they all fall still under the Controlled Substances Act in Mississippi as Schedule I controlled substances. When that opinion was issued, a group of businesses filed an injunction in Grenada County in Mississippi, asking the court to issue an emergency TRO and find that the Attorney General's opinion was not based in law and they're void in terms of effect and force. A chancery judge on the 12th of this last month issued an opinion stating that denying their request for injunctive relief and finding that the AG's opinion is not entirely wrong. What's a little more troubling about the judge's ruling is that it says because the Mississippi Hemp Act only talks about cultivation, the judge's belief is it does not legalize or create an allowance for any products created downstream from that cultivation. That is a worrying opinion to have out there, certainly in the state of Mississippi for anybody who's still operating there, but even just out in the world for other judges to potentially look at and rely on. Tennessee, we have a win. Tennessee is about to adopt a significant regulatory framework that goes into effect January 1 of 2026, where most of the regulation moves from the Tennessee Department of Agriculture to the Tennessee ABC Board. However, the Tennessee Healthy Alternatives Association entered into a negotiation with the Tennessee Departments of Agriculture and Revenue to come to an agreement that allows anyone who's had a license under the Tennessee Department of Agriculture issued before December 31 of 2025 to continue to operate under that license and the old rules until that license expires. What that means is that THCA flower, higher milligram products, other synthetic or semi-synthetic products will continue to be legally available and sold for those who have a license from the Tennessee Department of Agriculture that was issued prior to December 31, 2025. Missouri. The Attorney General has begun a new statewide investigation of intoxicating hemp products in the state of Missouri. They've begun that investigation with sending 5 civil investigative demands to specific retail shops in and around Missouri that they deem to be the ones responsible for the most movement or sale of intoxicating hemp products in the state of Missouri. They have alerted them that the sale of chemically altered or synthetic THCA-like compounds, including Delta 8, Delta 10, THCP, HHC, and THCO, is illegal and cannot be sold in the state of Missouri. The problem is the CIDs, if you get into them, have some more worrying definitions of semi-synthetic and synthetic if you are a Missouri operator or you are selling in Missouri. It does not just stick to what we would commonly think of as synthetic cannabinoids like THCO or HHC or THCP, and has much broader definitions and includes THCA in its designation of those that are considered semi-synthetic or synthetic. So that means they could come after not just the quote-unquote synthetic products, and depending on how you define it, but they could come after any hemp flower product, or really any product, because unless it's a Delta 9 isolate or a CBD isolate, you're going to have THCA in the product. That's to be aware of for any Missouri operators. Definitely worth taking a look at those. Again, we'll put a link to them in the notes. The next 365 days is going to be full of regulatory changes and shifts and interpretations, both at the federal, state, and local level. I anticipate many stops and starts and significant battles on a state by state. basis, which is why these updates will become more and more important. So if you are new here, please hit subscribe, come back. We'll continue to update you as time goes on. If you're a returning listener, thank you for coming back. Please share this with anyone that you think needs it or would find it helpful. If you have a business and you're selling in more than 10 states and you need some more personal attention for your business or your specific product line, we do offer 50 state summaries or chosen swath summaries, meaning if you only want 20 states, we work with clients based on their need. And we'd be happy to talk to you about your business's needs to keep you protected and thriving. I hope that this was helpful to you. Stay tuned. We'll see you next month. Here's to hoping we all get up off the mat.